My name's Stephen Denyer. I'm the Director of Strategic Relationships for the Law Society of England and Wales. I would like to welcome you on behalf of the Law Society to this Brexit Roundtable. We're going to be discussing the evolution of market access in EU jurisdictions post-Brexit. If you would like to keep your microphone on mute and keep your camera off, that would be great. If you could submit comments or questions by writing in the comments section, we will be aiming at answering all questions during the course of this presentation, but any that we don't manage to get to, we will pick up in writing subsequently. So, as you all know, when the UK leaves the single market and the customs union at the end of 2020, the EU Lawyers Directive will no longer apply to us. So, of course, coverage by the EU directives has for decades allowed solicitors to advise their clients across the EU, EEA, Switzerland on English law, EU law, international law, and the law of the host state, both on a permanent and temporary or fly-in, fly-out basis. All communications with EU clients have been protected by EU legal professional privilege. Lawyers have been able to represent clients in the Court of Justice and in the domestic courts to form partnerships with lawyers from all EU, EA states and Switzerland. Once we're outside of the directives, assuming that legal services are not covered by any future trade treaty, UK solicitors and their law firms will, as of January next year, be subject to the rules for third country lawyers and law firms. This means that instead of dealing with a single set of rules valid throughout the EU, EEA and Switzerland, UK solicitors and law firms will be subject to 31 different regulatory regimes, one for each of the 27 EU member states and 4 EFTA countries. Any firm that provides services to EU-based clients, whether remotely through branch offices or on a fly-in and fly-out basis, or operates in EU law heavy practice areas such as competition, will need to consider the implications of this change for their business. The Law Society has carried out extensive research into the rules that apply to third country lawyers in each of these jurisdictions, and today 2 of our Europe policy advisors, Marco Ciralio and Michael Padua, will go through the details of the rules in 10 key markets: Germany, France, Belgium, Ireland, Luxembourg, Spain, Greece, Switzerland, the Netherlands and Italy. Each country will be discussed for a set amount of time, and people are logging in, logging off, depending on what they're interested in. So I, as the chair, will be keeping things on time, I hope, which I seem to be succeeding in doing at the moment, and also will be picking up the questions that you submit in the chat function. Please keep yourself on mute, keep your camera off unless you're speaking, which is what Marco is about to do. So Marco, let me invite you to illuminate yourself and address Germany.
Thank you, Stephen. Hi, everyone. Nice to connect, or with some of you reconnect. So let's begin by discussing Germany, which for obvious reasons has been at the very top of our priorities for many years now, in terms of looking at the situation for solicitors and UK law firms after the end of the transition period. Obviously, we're talking about the largest legal market in the EU, the largest economy of the bloc by some distance, and unsurprisingly, it's also the market with the highest number of solicitors who operate there, either on a permanent basis, on a fly-in, fly-out basis. It also has obviously a large number of law firms that operate there through branch offices. When looking at the situation for solicitors and law firms in Germany post-transition period, we have focused particularly on three key areas. The situation for UK solicitors practicing in Germany on a temporary basis or flying in and out of Germany, the conditions for UK solicitors to establish in Germany and advise on UK law and international law on a permanent basis after the end of the transition period, and then legal structures that firms can use to operate branch offices in Germany, UK LLPs in particular. So I'll begin by discussing these 3 points, then I'll open it up for questions and perhaps touch on a few other areas afterwards. Now, in Germany, the situation is quite complex for each of the areas I mentioned. As far as temporary practice or Fifo is concerned, we are not aware of any specific provision in German law which either permits or prohibits Fifo or temporary practice by third country lawyers in Germany. What this means is that UK solicitors flying in and out of Germany after the end of the transition period, so from next year onwards, will be operating in what we could call a legal vacuum, so a situation where the law doesn't say one way or the other whether that's allowed or not. Now, there are a few things to observe here. Now, on the one hand, we do know that non-EU lawyers, US lawyers in particular, have been providing services in Germany on a fly-in, fly-out basis for a long time, and we're not aware of any action taken against them. However, on the other hand, the definition of reserved legal activities in Germany is extensive, and therefore some stakeholders in Germany are interpreting this as meaning that Fifo will not be permitted to UK solicitors post-transition period. It is also worth bearing in mind that whenever firms operate in a situation of legal vacuum, there is the chance that perhaps a disgruntled client might raise issues with the fact that legal services were provided in a way that is not explicitly permitted in German law. We think the rule on Fifo is unlikely to change to allow for more favorable conditions for UK solicitors post-Brexit, because that will trigger the most favored nation principle in GATS. However, there are questions as to how any prohibition on Fifo could be enforced. Normally, prohibition on Fifo are very difficult to enforce for local authorities. So this is the situation where UK solicitors are likely to operate as of next year. As Law Society, obviously, we will continue monitoring the situation. We will raise to members if we see an issue or a likelihood of enforcement rising in Germany. I mentioned that the second area that we've been focusing on is the ability of UK solicitors to establish in Germany on a permanent basis and advise clients at least on UK law and international law after the transition period. Now, as in all EU countries, and we'll touch on this a number of times today, talking about several of the discussing, after the end of the transition period, UK solicitors will no longer be able to register as EU lawyers in Germany. That's because obviously the EU directives, as Stephen explained, will no longer apply to UK solicitors and law firms. However, Germany has a list of foreign legal consultants that is open to non-EU lawyers. Lawyers can register on this list and advise German clients on their home country law and international law. There is, however, a condition for registration on this list. The foreign lawyer who registers as FLC in Germany needs to be registered with a bar association and exercise a profession in their home country, which is comparable in terms of education, competencies, and legal position to the position of a German qualified lawyer. This assessment is carried out by the Federal Ministry of Justice in Germany in consultation with the German Federal Bar, the BRAC. And the countries which fulfill these conditions are listed in what is called Article 206 of the German Federal Lawyers Act. So lawyers can only access FLC status in Germany if their home country is listed in 206 BRAU. Now, we have, as a law society, been working to ensure that the UK professions are indeed listed in 206 Brau as of January 2021, so that solicitors, even if they can no longer register as EU lawyers in Germany, they can register as FLCs and therefore advise German clients on UK law and international law. Obviously, the UK cannot be on that list until the end of 2020 because the UK is still covered by the directives, the EU directives until then. We are cautiously optimistic that the UK will be on that list in January next year, and therefore members will be able to register as FLCs in Germany. Obviously, we'll keep everyone posted on this. The third area I mentioned, and it's the last one I'm going to address before we open it up to questions, is legal structures and UK LLPs in particular. Obviously, we know that a large number of UK firms operate in Germany as a branch of UK LLPs. Now, the question has been whether UK LLPs can continue operating in Germany after the end of the transition period. The answer is yes, as long as the UK LLP have their center of administration and control in the UK rather than in Germany. So that is the condition. There are, however, some further conditions. So firms operating in Germany as branches of UK LLPs with their center of administration in the UK should bear in mind a few other elements, a few other points. Now, I was talking about the legal vacuum, the situation of Fifo to Germany. There is a similar situation for German qualified lawyers operating and working for UK LLPs in Germany after the end of the transition period, in the sense that there is no legislation in Germany currently stating whether UK LLPs can provide legal services and have right of audience in German courts. Now, German litigators who work for UK LLPs in Germany can still appear in court, and right of audience is assigned to each of them individually, rather than being assigned to the UK LLP overall. We understand that this will continue to be the case after the end of the transition period. So German lawyers working for UK LLPs can still appear in court because they will be authorized individually by German courts to do so. We also understand that there is draft legislation which is currently under discussion in Germany to positively state in German law that any third country structure, any legal structure from any WTO member state can provide legal services and have right of audience in Germany, as long as at least one of their partners or shareholders is a German qualified lawyer or a EU qualified lawyer. This means for UK LLPs that once this legislation comes into place, once this legislation is implemented, the right of UK LLPs to provide legal services in Germany and appear in court in Germany will be protected once and for all. However, we understand that it's very unlikely that this legislation will be in place by the end of the transition period. And obviously, as with any draft legislation, the final form this law ultimately takes might be different than what it is currently in the draft. What this all means for UK LLPs is that they can indeed continue operating in Germany as long as I said, their center of administration is in the UK and not in Germany. However, they should bear in mind that the right of audience of their German qualified lawyers will not be protected by the German law for a certain time, for the sort of interim period between the end of the transition period and the time the new legislation in Germany comes into force. Now, we understand that it's very unlikely that the German local bars, which are the competent authorities, will take any action against UK LLPs during this sort of interim period before the new legislation comes into place. And we also understand that German courts will continue to allow German qualified lawyers working to appear in court. However, firms will obviously have to bear in mind the consequences of operating in Germany as a UK LLP. during this interim period. It is possible that their German qualified lawyers will assume increased personal liability exposures if they practice for UK LLPs, and firms might have to consider whether their professional indemnity insurance apply and will apply to the lawyers, to German qualified lawyers in Germany during this sort of interim period. I will stop there. I touched on the sort of three key issues that we've been looking at in Germany. I just would like to see if there is any question at this stage. Stephen?
So as I mentioned, please put any questions in the chat. There are no questions in the chat yet, but if you do have questions about Germany, we'd love to hear them. And the same is going to apply to other countries as we go through them. So get ready to put your questions in there as well. As you will have gathered from what Marco said, we've been having very extensive discussions with the various relevant bars and authorities in Germany, and as you'll hear as we go through the presentation, the same applies to other jurisdictions as well. So we are very well placed, I hope, to continue to pursue these issues. Right, we have a question. Fly in, fly out. Legal vacuum applies only for advice on UK/international law, or also for advice on EU law? Marco?
No, advice on EU law FIFO is not permitted in Germany. Now, obviously, the same issues about difficulty of enforcement applies to EU law, advice on EU law. However, and this is something that is worth bearing in mind for all the countries we will address today, indeed all EU countries, the qualification of UK solicitors as of January next year is no longer an EU qualification. So it no longer gives solicitors the right to advise clients on EU law. So the answer is no. Legal vacuum is for advice on UK law and international law. Advice on EU law in Germany after the end of the transition period is not permitted by UK qualified solicitors. Obviously, it will be permitted by German qualified lawyers working for UK firms.
Okay, next question. Is FLC status applicable to persons permanently based in Germany, or can it apply to lawyers based temporarily?
No, that's only for lawyers who are based permanently in Germany. Germany has no FLC status for temporary practice and for FIFO. So you need to be established in Germany to qualify.
Yeah, so just traveling to Germany regularly, that's not enough.
No, there needs to be an establishment in Germany. It depends what regularly means, obviously. If it's the requirement is for an establishment in Germany. Yeah.
Yeah, okay. The next question, is it your understanding, sorry, it's now moving off my screen. Hang on. Is it your understanding that the new legislation which is awaited will permit UK LLPs which have a centre in Germany?
No, UK LLPs will, obviously it is still a draft and we haven't seen the draft. We understand it from people who have and we've spoken with. No, the centre of administration will need to be in the UK because the draft legislation will allow third country structures from WTO countries. And the problem with UK LLPs with centre of administration in Germany, that's simply not a recognized form in Germany at all. So yes, the central administration will still need to be in the UK for UK LLPs.
Okay, it's a bit like Mastermind, isn't it? FIFO, is a UK LLP, if a UK LLP has lawyers with continuing EU qualifications, e.g. dual qualified lawyers, can they provide EU advice on a FIFO basis? I think you just said it could, but you mentioned only German qualified.
Yeah, EU qualified. So I guess we're talking about EU qualified lawyers who are based in the UK and whether they can fly in and out of Germany. Yeah, it's a tricky one. It depends whether they are EU citizens, because if they are EU citizens and EU qualified and based in the UK, they can FIFO to Germany. If they are UK citizens, the position might be slightly trickier, although our understanding is that to Germany, yes, they will still be able to fly in and out if they have a EU qualification but the position is clearer for EU citizens who are also EU qualified.
Okay. If a UK lawyer advises on EU law in tandem with a German qualified lawyer, would this be okay?
It will be okay for coverage by EU legal professional privilege. It depends what we mean by okay. It will ensure coverage by EU legal professional privilege. I'm not sure what we mean here by being okay. It depends from which perspective we're looking at it.
All right. And maybe one we need to follow up subsequently then. By the way, if we haven't fully answered questions, do get in touch afterwards as well. We'd be happy to pursue them. Are the Law Society going to try to coordinate an approach to PI providers to clarify the position? Should the SRA be asked about the implications?
I guess we're talking about the case of UK LLPs in Germany post-Brexit. I mean, we could. At the moment, we are monitoring the situation and trying to get more details on this draft legislation. But if that's helpful to members, we will certainly explore this possibility. Yes.
Okay. One last question. I think you said there can be no new applications for English lawyers to be qualified in Germany. However, if already qualified, presumably that qualification still stands in 2021.
Yes, absolutely. Yes.
That was a very straightforward answer. Right, we're going to bowl on to France, and Marco, you're still in the mastermind hot seat.
I am, yes. So France, I guess the situation in France is more straightforward than Germany, which doesn't necessarily mean that it's better for UK solicitors and law firm after Brexit, but it's certainly clearer than Germany. In France, we've been focusing on similar topics to Germany, but I'll address them in a different order. So we have been looking at the situation for UK LLPs in France after the end of the transition period. We have been looking at the conditions for UK solicitors to establish in France and advise on UK law and international law after the end of the transition period, and at the conditions for UK solicitors to fly in and out of France after the end of the transition period. On UK LLPs, now, in general, the LLP is not a recognized legal structure in France. This means that UK law firms will not be able to establish in France as branches of UK LLPs after the end of the transition period. However, the French government has been working on an ordinance to grandfather the rights of UK LLPs that are already established in France. This would mean that all firms that have already opened branch offices in France at the end of the transition period and are working through branches of UK LLPs can continue operating in France. Now, the ordinance has not been published yet. We expect it to be published in a matter of weeks. We have long been working with a lobby group of UK and US law firms in Paris towards this objective. I will go through the steps so far very quickly. In June 2020, the French Parliament passed an act which empowers the French government to rule by decree on this matter. So this act empowers the French government to take the regulatory measures that may be needed to preserve the rights of British nationals that are resident or operating in France at the end of the transition period. This article also mentions explicitly legal entities established in France whose shares or voting rights are held by entities established in the UK, such as UK LLPs. As I said, in a matter of weeks, the government should follow this act by publishing an ordinance to enact this legislation for UK LLPs. We understand that the government has been consulting with the French National Bar, the CNB, and the Paris Bar on this matter. We understand that the position adopted by the CNB and the Paris Bar in their consultation with the government was that they advised the government to indeed go ahead with the publication of the ordinance so that UK LLPs can continue operating without needing. So we are optimistic, I should say we are cautiously optimistic that this will go ahead and UK LLPs will not have to restructure. The second point we've been looking at is establishment rights for individual solicitors after the end of the transition period. So can UK qualified solicitors continue advising clients in France on UK law and international law at least after the end of the transition period? Now, two things to consider. We understand that the CNB and the Paris Bar have recommended that the ordinance published by the government in a matter of weeks also includes provisions that grant a 1-year grace period to solicitors and barristers that are already operating in France as of the end of the transition period and are registered as EU lawyers in France, and gives them an even longer time to requalify as French advocates through the EU Establishment Directive, so after 3 years of continuous practice and registration in France. So we understand that this ordinance, which is expected in a matter of weeks, might cover individual practicing rights as well. I would say we are perhaps less optimistic on that, because the problem is that the SRA in the UK is not giving the same rights to French lawyers operating here. So EU lawyers operating in England and Wales will not have any grace period after the end of the transition period to requalify as UK solicitors. So it has to be seen whether an EU member state such as France will sort of unilaterally grant this right to UK solicitors operating there. Beyond that, so after the period covered by the ordinance, if the ordinance indeed covers individuals, there might still be a path for UK solicitors to establish in France and advise clients on UK law and international law, because France has, like Germany, foreign legal consultant status for non-EU lawyers. However, there is a condition for registration as FLCs in France. And the condition is that the lawyer registering as FLC in France needs to come from a country that has a FTA with the European Union, which covers legal services. Now, obviously, we don't know yet whether there will be indeed an FTA between the UK and the EU. We don't know yet whether this FTA will qualify for registration to enable UK solicitors to register as FLCs in France. But certainly as a law society, as soon as we have certainty on the FTA, and if indeed there is an FTA between the UK and the EU, we will push for this FTA to qualify, although obviously we don't know yet what the outcome will be. Now, what we can say, I guess, is that France has accepted recently applications for FLC status from a lawyer who is qualified is Colombia. There is an FTA between the EU and Colombia, which was signed in 2012, and on the basis of this FTA, the application was accepted. So, as I said, when we have certainty on the FTA between the UK and the EU, if there is one, we will make sure we push for it to qualify. Very briefly on fly out, there is a similar situation as for establishment. France is quite unique in that France has an FLC status scheme for temporary practice as well as permanent practice. So if there is no FTA between the UK and the EU, UK solicitors will not qualify for FLC status in France, which means, strictly speaking, they will not be able to fly in and out of France to advise clients. It's worth saying that, as in Germany, we know that Fifo is happening by US lawyers. So US lawyers regularly fly in and out of Germany outside of any FLC status scheme. It is worth noting, however, that the new regulation in France for FLC status for Fifo has been implemented recently. So there has not been enough time for us to really say whether France intends to enforce restrictions on Fifo for third country lawyers who don't qualify for FLC status. But obviously, again, we'll keep on monitoring the situation here as well. So I will take a look at whether there are any questions now.
There are indeed questions. so we're well placed to address those. So, first question is, when you say branches of UK LLPs, my understanding is that the Paris business is a separate LLP allied to a UK LLP, and where it is truly a branch in corporate terms, i.e. part of a bigger LLP.
Yeah, that we are not aware of any distinctions between the two. I guess in that it's different to Germany in this. We're not aware of any distinction. We are aware, obviously, there was an ordinance that France passed last year to protect the rights of UK LLPs established in France. I don't think this ordinance made any distinction between the two of them. This ordinance obviously is no longer valid because it was supposed to come into place back in 2019 in case of no deal. Because of the withdrawal agreement, that ordinance now needs to be replaced by a new ordinance, which is the one I described, which shouldn't make any difference between the two types of UK LLPs.
Okay. What is the position for UK solicitors practicing permanently in France now, but who will not have 3 years even after the grace period?
So the grace period should, and again, on that we've got less certainty, but we understand that the grace period should be longer if someone needs more than a year to requalify. Again, we need to be very careful how we phrase this because there is no certainty yet. We do understand that the grace period will aim at enabling possibly all those who are registered as EU lawyers to requalify in France as French advocate, but we'll have more on that as soon as the ordinance is published, which should be very soon.
Fifo. Can UK nationals with continuing dual EU qualifications advise on UK, international and EU law in France on a Fifo basis, and any difference between UK and EU nationals working in the UK for an English LLP?
Yes, so the problem here is that in order for a UK-based lawyer to be able to fly in and out of France outside of the FLC scheme, they need to be covered by the EU Lawyer Services Directive. Now, the EU Lawyer Services Directive only applies to those who are EU qualified and EU nationals. So yes, unfortunately, the requirement is also that there needs to be EU nationality for Fifo to France through a EU qualification.
And another Fifo question, can a UK lawyer advise alongside an EU qualified lawyer? Will that assist?
Yes, it will assist with EU legal professional privilege. So if that happens, if they advise jointly, then the advice will be covered by LPP. However, no, I'm not aware of that assisting in terms of Fifo in and out of itself. So we'll still need to look at whether the UK qualifies for registration as FLC status after the end of the transition period.
One thing that's really struck me about France is that particularly if you look at the Paris bar, there are a significant number of partners in international law firms, often either headquartered or with operations in England, who are on the council of the Paris bar. And over the years, we've had quite a few batoniers of the Paris bar who come from international firms. Do you think that's helped with all of this, or hindered, or a bit of both?
No, it has helped. I mean, I have to say, I mentioned briefly earlier that the government consulted with the CNB and the Paris Bar, and I have to say the Paris Bar was very supportive of our position. We understand that the advice they gave to government is that they should publish the ordinance to protect UK LLPs, and this ordinance should also include provisions for individual lawyers. So certainly the Paris Bar is on our side in this. Obviously, the final passage needs to be the government, the French government, publish the ordinance. But yes, Paris Bar, as far as we understand, has been supportive. Yeah.
Another question, is there any legal work that is not reserved only to French avocat EU lawyers or those qualified under advocacy scheme?
So, yeah, so there is obviously advice on international law, for example, is not reserved. But again, the point is that regardless, to provide any kind of legal advice in France, one needs to be registered as a EU lawyer in France. One thing that is perhaps worth noting as well is that arbitration is governed by the Code of Civil Procedure. I'm not going to try to pronounce it in French. And this code does not prohibit representation by foreign lawyers. So yes, arbitration is perhaps one area where you might be looking at in terms of representation of clients. But beyond that, France obviously has a lot of activities reserved to French advocates. And even beyond that, there is the FLC scheme, and you need to register, strictly speaking, to advise in France.
Okay, and another question, both France and general EU question. Can a UK-based lawyer continue to advise UK-based or third country-based clients on EU law, e.g. GDPR obligations?
Yes, obviously there is no restriction on provision of EU law advice in England and Wales, so yes. However, there are a few things that is worth bearing in mind, and the main one is protection by EU legal professional privilege. So the advice to clients will not be privileged if there is any investigation by the EU Commission or any other action by EU bodies, unless there is a EU qualified lawyer who is also working alongside the UK qualified solicitor. But if EU legal professional privilege is not an issue, then yes, UK qualified lawyers can continue advising on EU law in England and Wales.
Very good. Now it's time to move on to Belgium, which is also you, Marco.
Yes. Yes, so Belgium has also been one of the priority countries we've been looking at. There are obviously a huge number of solicitors and law firms operating in Belgium. This is obviously mainly due to Brussels as a big legal center, particularly for EU heavy practice areas and competition and antitrust, obviously. There is an even larger numbers of solicitors who operate in Belgium on a fly-in, fly-out basis. I guess there are quite a few good news on Belgium, which is nice to follow after France, where the situation is a bit more complex. One, we have a very positive relationship with all the Belgian bars, and this has really helped over the last few years. And two, Belgium has quite a liberal regime for non-EU lawyers. So I'll go quite quickly on the issues in Belgium. Fifo. Can UK solicitors continue advising clients in Belgium on a fly-in, fly-out basis? The answer is yes. Belgium formally does not have FLC status for temporary practice. However, we understand that Fifo is permitted for third country lawyers. Then the other issue that we'll be looking at is, can UK solicitors continue advising Belgian clients in Belgium on a permanent basis? The answer again is yes. Belgium has a scheme for third country lawyers. It is what the so-called B list, list B, the list of associated members of the Belgian bars. Now, registration on this list is mandatory. If a UK lawyer is practicing jointly with Belgian or EU qualified lawyers. And it also provides some additional practicing rights, and I'll go through that in a minute. And it also ensures coverage by legal professional privilege in Belgian domestic courts. Obviously, EU LPP is a different issue, but as far as Belgian courts are concerned, registration on the B list ensures protection by legal professional privilege. However, if you're not interested in any of this, registration is optional, meaning that you can still advise clients on UK law and international law in Belgium without registering. If you do register on the B list, I said there are some additional practicing rights that UK solicitors can enjoy as of next year. The interesting thing is that these additional practicing rights seem to differ depending on which bar you register with. If you register as a B list lawyer with the Dutch-speaking Brussels bar, then you can advise on some aspects of Belgian law as well as EU law, as well as obviously advising on home country law, so UK law. However, you cannot appear before Belgian courts. That's reserved to Belgian and EU qualified lawyers. If you register on the B list of the French-speaking Brussels Bar, then you can only advise on Belgian law on a strictly incidental basis, and you need to be working jointly with a fully qualified Belgian lawyer. Or there is the option also to working jointly with a trainee lawyer who needs to have at least 1 year of training completed. Now the B list, registration on the B list requires maintaining a local address in Belgium. And you also need to obtain the status of an independent or one-person company. This is because Belgian lawyers cannot be employed by law firms. They can only operate as independent or as sole practitioners. If you are still based in the UK, before moving to Belgium, you need to apply for what is called a professional card. This application takes around 3 months, and only on the basis of this professional card can you obtain a visa to travel to Belgium and establish there as a B-list lawyer. So that's as far as practice of UK law and international law is concerned. On legal structures, again, good news. UK LLPs will be able to continue operating in Belgium after the end of the transition period. We're not aware of any issue there. However, another point that is very relevant in the case of Belgium are the conditions for requalification as a Belgian lawyer. Belgium, for fully qualified Belgian lawyers, has the so-called A list. There is a nationality requirement for requalification as a Belgian lawyer for admission to the A list. So the nationality requirement states that one must be either Belgian or a EU citizen in order to qualify for full admission to the A list in Belgium. We are working on this. We signed the memorandum of understanding with the Belgian bars about a year ago, and they committed to lobbying the Belgian government for the removal of the nationality requirement for requalification as a Belgian lawyer. This process has been delayed, unfortunately, due to the fact that Belgium hasn't had a functioning government for quite some time. The current Belgian government obviously is dealing with the COVID-related emergency, but in a recent call we had with the Belgian bars, they reinstated obviously their commitment to lobbying the Belgian government. So they are working on this now. Although this process might not be completed by the end of the transition period, we'll keep on working on this. Now, the other question that has come up very often is, what about those who have requalified already as Belgian lawyers or will requalify as Belgian lawyers by the end of 2020? Will the nationality requirement be valid of them as well? Will this be an issue for UK nationals who don't have EU nationality and are currently on the A list in Belgium? Will they lose their right to be on the A list in Belgium? The answer is no. The nationality requirement will not apply retroactively, which is good news. So whoever qualifies as a Belgian lawyer by the end of 2020 will be able to remain on the A list and be a fully qualified Belgian lawyer after the end of the transition period as well. There is another issue that has come up, which is, what about UK nationals who requalified as Belgian lawyers and then moved back to the UK? Will they still be able to operate as Belgian lawyers? The answer is yes, which is again another good news. The condition is that they maintain an address in Belgium. This doesn't mean that they need to be resident in Belgium. We understand that the Belgian bars have interpreted this requirement quite flexibly. So as long as a lawyer has an address in Belgium where they can be contacted, which could be, for example, your firm's branch office in Belgium, as long as you have an address in Belgium where you can be reached, you can continue being on the A list in Belgium and operate as a Belgian lawyer, even if you are based in the UK. So I guess that's quite a lot of positive news on Belgium. Stephen, are there any questions?
There are indeed, yes.
Okay, great.
Can UK lawyers advise on EU issues within Belgium if they're there on Fifo visits, or is it just UK and international law?
So on Fifo, again, we understand that the regime in Belgium is relatively liberal. So the answer would be yes. You can advise on EU law on a temporary basis in Belgium. As far as the Belgian bars are concerned, always worth bearing in mind that the UK qualification no longer ensures coverage of legal professional privilege after the end of the transition period. So that's one issue that is worth bearing in mind. But beyond that, our understanding is yes.
Are there any PI implications for B-list lawyers if they have to operate in individual capacity and not through an LLP?
Not that I'm aware of. We might have to double check on this, but that has not come up as far as I'm aware in our conversations so far.
Yeah, I think it's fair to say on PI questions we haven't necessarily tested the market, so so anything we say on PI I think is to be taken as indicative at this this stage, but we're happy to pursue things offline as well on that. Right, next question: can you join the B list if you are not based permanently in Belgium?
No. You need as I explained briefly, you do need to have a local presence in Belgium, which needs you to go through application for a professional card and then a visa to travel to Belgium and register on the B list. However, Fifo, as I said early on, discussing Belgium, is permitted even if you're not registered on the B list.
Okay. I understand that UK nationals who have already exercised their rights and been sworn onto the A list in Belgium will be protected, and the EU nationality requirement won't be exercised retrospectively. What is the position for UK nationals on the E list in Belgium? A, if they remain UK only lawyers, and B, if they're dual qualified in Ireland, i.e., can they stay on the A list if they're already there, or will they be moved onto the B list?
Okay, that's a very interesting question. So Ireland, we'll touch on Ireland. It's the next country I think we discuss. So the E list is for EU qualified lawyers. So if UK solicitors do not have any EU qualification, they will have to move to the B list, which we described. If they have an Irish qualification, our understanding is that they can remain on the E list as long as they are resident in Belgium as of the end of the transition period. I will explain this very briefly now, and then we'll probably go into more details on this when we discuss Ireland. As I said earlier, the EU directives require EU nationality. So strictly speaking, if you are a UK citizen, you cannot benefit from the directives after the end of the transition period. However, if you are resident in an EU member state, based on the Citizens' Right chapter in the withdrawal agreement, you should still be able to benefit from the EU directives if you have an EU qualification, such as the Irish one. On this basis, we believe that, yes, you can keep on being on the E list after the end of the transition period. This is certainly the position that we will make clear with the local bars, and we already have, and we have asked confirmation from them. But this remains our interpretation of the withdrawal agreement. So we believe that that's the case. Yes, you can remain on the E list. Was there any other case addressing that question, Stephen?
No, I think you've covered it. Two more questions. Does operating independently mean you must set up a company to operate through?
No, you can operate as a sole practitioner. This is referred to the fact that, as in some other EU member states, strictly speaking, Belgian lawyers can, associated members of the Belgian bar cannot be employed by a law firm. But no, it doesn't mean that you have to set up a company operate as a sole practitioner, as a self-employed.
And then yes, sorry, there is a follow up to the
Okay.
E list B list question, which is, so is the residency requirement under the E list stricter than under the A list?
Is what, sorry, the residency?
Is the
Oh.
residency requirement under the E list stricter than under the A list?
Yes, I mean, it's worth bearing in mind that we're talking about two different things. One is the rules that the Belgian bars have for A-list members, and that's up to them. The other one on the E-list, that's a EU-wide directive. So that's the requirement to qualify for the EU directive. So yeah, as a matter of fact, it is stricter, but not because the Belgian bars make it stricter. It's because they have less room for maneuver on the E-list, because the E-list is connected with the EU directives. So yes.
Okay, so before we give you a well-earned break, Marco, you've still got to deal with Ireland.
I do, yes.
Sorry, there's another. Sorry,
yes, sure.
just before that, there is another Belgian question. If a UK national is now on the E list, will he go to the B? To go to B list, will he need to be qualified in an EU state? Is registration in, say, Ireland sufficient, or is an Irish PC necessary? A bit of a crossover question with Ireland.
Yes, so no, so for the B list, no, the solicitor does not need a EU qualification to be on the B list. The B list is open to the B list is for third country lawyers. So the UK qualification is sufficient to be on the B list. If we are talking about the E list, then yes, the qualification in Ireland is required. And we believe the Irish PC is also required, although that's something we can check with the Belgian bars. But if we're talking about the B list and the question asks about the B list, no, you don't need a EU qualification to be on the B list.
Very good. Okay, now you can move on to Ireland.
Great. Okay, so yes, Ireland. Now, I will go very quickly on the sort of country, on the situation in Ireland. Ireland is a very liberal country. It's very similar to the UK, to England and Wales, actually, in that essentially there is, I mean, anyone can give advice on any types of law in Ireland, apart from the reserved activities. Which are, again, very similar to the ones we have in England and Wales. So reserved activity being probate litigation and conveyancing, and obviously, so representation of clients in court and the use of the Irish solicitor title are reserved for Irish qualified lawyers, but otherwise, any advice on any type of law on a permanent or temporary basis is allowed for third country lawyers. On top of that, obviously, UK solicitors, so England and Wales qualified solicitors, can apply with the law site of Ireland for requalification as Irish solicitors without needing to sit any test. They only need to apply for a certificate of admission. This will continue being the case after Brexit. This will not change with Brexit. The common travel area and the right to travel to Ireland will not change with Brexit, we understand. So requalification as an Irish solicitor and right of establishment for individuals will be fairly liberal post-Brexit. Now, I am well aware that when we talk about Ireland, that's not the main issue in everyone's mind. The issue is, okay, I requalify as an Irish solicitor. I have an Irish practicing certificate. What does the Irish practicing certificate enables me to do if I am not based in the Republic of Ireland? And that's where the situation gets quite a lot more complicated. Probably many of those who are listening to this are aware of the Law Society of Ireland taking initially a very open and liberal position, proactively inviting UK solicitors to requalify in Ireland to continue benefiting from the EU lawyers' directives. And then at one point, about a year ago, actually over a year ago, assuming a progressively more restrictive position. Now, the latest we hear on this is the latest we understand from this on the Law Society of Ireland that in the 2020 Irish Practicing Certificate renewal form, applicants for renewal were asked to confirm and sign the following statement. I confirm that I'm aware that an Irish Practicing Certificate only entitles the holder to an EU legal while in the Irish state, except as provided for under the EU Services Directive and the EU Establishment Directive. Now, this means, strictly speaking, that the Law Society of Ireland does not basically the Irish Practicing Certificate is not valid to practice as an Irish solicitor and advise on Irish law and EU law when the holder is based in the UK. Now, where the complexity arises is that how should we read this statement by the Law Society of Ireland? Is it really up to the Law Society of Ireland to say that the Irish PC is not valid outside of Ireland? And this is where opinions diverge. The statement by Law Society of Ireland must be read in conjunction with what we think is the regulatory reach of the Law Society of Ireland, and must be read by as meaning that the Law Society of Ireland can only guarantee that the Irish PC will enable you to practice Irish and EU law if you are situated in Ireland. So we appreciate that this position is not helpful to Irish PC holders based in the UK, but this is where we are at the moment. The Law Society of Ireland have told us that as long as, until there is more certainty coming out of the UK-EU negotiations, they do not want to engage on this topic any further, which means where we are at the moment is the statement I read to you. We can interpret this statement. We can look at what you can do with an Irish Practicing Certificate in other EU member states, for example. But in the UK, if you're based in the UK, there is certainly this uncertainty as to whether you can still enjoy coverage from, for example, EU legal professional privilege if you are an Irish Practicing Certificate holder. Now, I guess there will be quite a lot of questions on this, Stephen. So,
yeah,
to you, yeah.
So the first question relates to Northern Ireland. Can English and Welsh lawyers practice in Northern Ireland from London, e.g., on medical law in Northern Ireland, which post-exit day will be EU law rather than retained EU law?
Yes. So, yes, in this not as much on it being on EU law. So strictly speaking, yes, because if you're not advising on any of the reserved activities, and we're talking about Northern Ireland anyway, not Ireland, you can provide advice. Always the note of caution is there is no protection by EU legal professional privilege if any issue arises with EU bodies, because the UK qualification is no longer an EU qualification. But as far as the practicing rights are concerned, if legal professional privilege with EU bodies is not an issue, then the answer is yes.
And obviously the relationship and requalification requirements with Northern Ireland and Scotland will not be affected by Brexit, I assume.
No. That's obviously it's a separate topic. It's with to do with the UK internal market. So we're not aware of any impact directly from Brexit on that.
Are you confident that we can still apply to requalify post 31st of December? The Irish Law Society has sat on the fence when we have asked the question, and by requalify, I mean apply for admission.
Yes, we had a recent conversation with the Law Society of Ireland, said they didn't want to engage on the validity of the PC, but when we discussed the requalification procedures, they confirmed that they will still issue Irish Practicing Certificate and enable UK solicitors to requalify in the same way post-transition period. I appreciate this member has had different information from Law Society of Ireland, but speaking with us, they have confirmed that will still be the case after 31st of December.
We have for a long time now been keeping in very regular touch with all EU who've expressed an interest in Irish qualification and the many twists and turns there. We will automatically add all of those of you who have not previously been on our distribution list for that to the distribution list. And obviously, I guess, Marco, we're hoping there may be some further news from the Law Society of Ireland once once it's clear how the negotiations with the EU on the FTA end.
Yes, absolutely. So two things we certainly commit to doing. One is obviously adding all members to this call to the distribution list on Ireland. We will also distribute our most recent update on the topic, which has more details compared to what I explained in a couple of minutes now. And the other thing is, as soon as there is certainty on UK-EU FTA or lack thereof, we will get back in touch with Law Society of Ireland and engage with them on the matter to clarify it. Yes.
And you won't be surprised to hear we have very, very deep and long-standing relationships with the Law Society of Ireland. Right, another question. How does PC renewal application statement impact Irish-based and qualified solicitors who have to travel outside the EU on a temporary basis to advise international clients?
Our understanding is that it does not impact them. So if there is an establishment in Ireland and the Irish solicitor is based mainly in Ireland, then they can travel and keep on advising on Irish law and EU law and international law based on their Irish practicing certificate.
Very good. Okay. Well, let's move on then to Luxembourg, and we're going to give Marco a well-earned rest and welcome Michael. Michael, maybe you'd like to join us and tell us about Luxembourg.
Right, we'll give Marco a break. So on Luxembourg, despite its small size and population, Luxembourg is an important financial center. In particular, Luxembourg is the second largest investment fund center in the world and the biggest in Europe. This has led to significant opportunities in cross-border tax planning, investment fund, real estate banking, and financial advisory services, and corporate M&A work. So our members have taken advantage of these opportunities. We have 14 member firms and 78 individual members in Luxembourg. Unfortunately, Luxembourg is a highly restrictive market for non-EU foreign lawyers. But in seeking to maintain market access for our members post-Brexit, we've had a lot of meetings and email exchanges with the Luxembourg Bar, in particular on firm structures, which we'll get to in a little bit. Beginning with Fifo, provision of temporary services by a lawyer from a non-EU member state appears to be forbidden in Luxembourg. However, as we've discussed with some other locations, we're certainly aware that it happens in practice with US and other foreign lawyers regularly flying in for client meetings without facing repercussions. So the Luxembourg City Bar Association seems to be relaxed about Fifo. And as a traditional bar, the Luxembourg Bar has told us that they are reluctant to act as an advisory body and that they prefer to be reactive rather than proactive in addressing issues. However, they will address issues that are raised by their members. So there is a potential risk to our members if a competitor complains about Fifo provisions of legal services by a UK firm or risk from complaints by a disgruntled client. So while the Luxembourg Bar may not be proactive in addressing Fifo by UK firms, complaints might trigger a reaction. But as we've discussed, it's hard to discriminate. It's hard to monitor Fifo, and it's also hard to discriminate against only UK firms without having to take action as well against other firms like US lawyers. Lawyers like US lawyers. Foreign lawyers can represent clients in arbitration, conciliation, and mediation. On establishment rights, Article 5 of the Loi du 10 août 1991 sur la profession d'avocat states that no one may practice the profession of lawyer if he or she has not obtained registration on the roll of a bar association established in the Grand Duchy of Luxembourg. And since there is no role in the Luxembourg Bar Association for non-EU foreign lawyers, we can infer that no foreign lawyers are allowed to practice the profession in Luxembourg. On legal structures, many of our members will be most concerned about legal structures, in particular whether the UK LLP will remain an accepted form or whether firms will need to restructure. And we held a roundtable on this topic with affected firms on September 3rd. Many of you will be aware of a circular distributed by the Luxembourg Bar in June of 2019 regarding profit sharing between lawyers and non-lawyers. Luxembourg lawyers are not allowed to share profits with non-EU lawyers. But the memo did leave open a window of possibility. The memo clarified that Luxembourgish lawyers can share profits with a lawyer from another EU member state, or a lawyer, quote, belonging to an organization representing the professional authority of a state which is not a member of the European Union, provided that the Council of the Luxembourg Bar has ascertained that this order or this organization ensures the conditions of registration, exercise as a profession and association equivalent to those provided for by the Luxembourg law regulating the legal profession in Luxembourg. So profit sharing with foreign lawyers would be possible if the foreign profession was recognized as equivalent to that of the profession in Luxembourg. This equivalence has never before been granted, so we knew that we'd be facing an uphill battle in convincing the Luxembourg Bar to accept English solicitors as equivalent. We understand that that question was considered by the Luxembourg Bar Council at a meeting on 16 September, and again at several subsequent meetings in September, during which they apparently were not able to reach a decision. The Luxembourg Bar reached out to us a number of times to clarify the SRA rules for authorization of firms in England and Wales. Their particular concern is the original sin of non-lawyers potentially being partners in a law firm. This is clearly the case in ABSs, but even beyond this, they were very concerned because in a recognized body, all managers and interest holders are lawyers or legally qualified bodies. A licensed body can be a legally qualified body if the lawyers in that licensed body are entitled to exercise or control more than 90% of the voting rights. So what struck the Luxembourg Bar is that this could mean that up to 10% of non-lawyers might take part in the control of a licensed body and be part of the ownership structure of a recognized body. So they were very concerned about this possibility that as diluted as it might be, there might be a non-lawyer component of ownership. So as I mentioned, the Luxembourg Bar has been debating this issue. Ideally, they will recognize the UK profession as equivalent, the first to be so. And this would then allow Luxembourg lawyers to profit share with UK LLPs as part of the UK LLP, as long as there are no non-lawyers as partners. This would mean that UK LLPs would not need to restructure before the end of the transition period. We believe that the Luxembourg Bar will be reaching a decision very shortly, and will be communicating that decision very soon. We will hopefully be able to communicate to our members that decision very soon. As soon as we're able to, rest assured we'll share the news about any decisions with you.
Michael, there's a general question that's been asked.
Mm-hmm.
I'm not sure whether that, I suspect the answer to this is going to be different for different countries.
Yep.
But the question is, if FIFO restrictions are enforced, what form could this enforcement take? E.g., could it be criminal sanctions? Presumably, in most cases, it's initially a matter for the bar, is that? Presumably.
Yeah, so it very much does depend on which jurisdiction in Europe we're talking about. It's a matter for national jurisdiction. And yes, it can be a criminal matter, depending on which jurisdiction we're talking about.
And the position in Luxembourg on that one?
I'm sorry, I'm just taking a look at my notes on Luxembourg to see if I have anything on that. Sorry, I'd have to look that up and see what the Luxembourg law has to say on the issue of penalties. Offhand, I don't know, but I can look it up.
Now, account opening documents. Do we have account opening documents?
Any other questions on Luxembourg?
Sorry, Stephen, we have a question from someone who cannot type the question because they've joined the via phone. Can we ask them to speak, maybe? Hello?
Marco, if you were referring to me, it's Raymond Cohen. I'm happy to just say a few words.
We might have
lost
great. I couldn't hear back from Stephen. Yes, please do.
And apologies. I think, and I don't know whether this is the same for others, but if you're not someone who's downloaded Teams, we can't participate in the chat, so it's not been able to. I've not been able to pass through any questions. But anyway, all I want to say about Luxembourg is that I understand that good progress has been made in discussions with the bar over the last few weeks, and that those firms who are present in Luxembourg will be getting direct communications from the Luxembourg bar about their position, and will be invited to exchange information with them. I'm very confident that my firm, having made an application to the Luxembourg bar, will be getting confirmation that equivalence is accepted in relation to our structure. But actually, individual firms will obviously be structured in different ways and will need to, I think, engage with the bar over the next few weeks in order to obtain the comfort that they individually need. But for the time being, until the bar has formally responded to them, actually, I think it's best for everyone just to wait to hear what they how they individually respond.
Thank you, Raymond. That's very helpful. And I think the good thing about having a round table is that members can contribute with very helpful new information. So yeah, we'll certainly work on this basis. I don't know if we've lost Stephen.
I'm back.
Okay.
I'm back.
Okay, great.
So apologies for that. My internet decided not to play ball. Anyway, I guess you've have you finished Luxembourg?
There were a couple of other questions, I think, on the chat. I don't know if we want to go through them.
Yep, let's do that.
I don't think any of these questions were answered.
Okay. What implication for LLP with non-lawyer EU members, such as German tax professionals?
That's interesting. I mean, I think the EU law would still apply for EU citizens, right?
Yeah, they should. Yeah, I mean, I think it's a complex position, but I think because of the EU directives, Germany should be included. But I do think that the Luxembourg bar will want to look at the members of each partnership. But obviously, Germany is still part of the EU, still part of the EU directives. So that should cover them. They should cover German tax professionals if they're in Germany and can be partners in Germany. But this specific situation will need to be looked at specifically, I think.
Yes, so Germany is one of those countries where non-lawyer tax professionals are allowed in partnerships, isn't it? Yeah.
Yeah, and therefore Luxembourg should recognize them too, because of the principle of mutual recognition.
I would have thought so. Yes.
Yeah.
If the decision is negative, will the Law Society argue for a transition period? There will not be time for firms to convert.
Yeah, so as Raymond mentioned, we're pretty confident that the decision will be positive. I mean, we recognize, and it's been a frustration for us, the Luxembourg bar has taken such a long time to reach a decision because it does not give firms much time to restructure if they need to. So the Luxembourg bar is aware of the importance to the legal services industry in Luxembourg of English firms. So I don't think they're looking to create unnecessary difficulties. So we would definitely argue with them for a grace period to make any necessary adjustments to remain in compliance with Luxembourgish law post-transition.
And another question, even if equivalence is granted, a UK LLP structure would not be recognised, and so the members would have unlimited liability. Is that correct?
Well, the issue I think was around profit sharing, was the objection to UK LLP. So the UK LLP structure would remain recognized if equivalence is granted to the profession here. Marco might want to weigh in on that.
No, our understanding is that yes, so the two things will be taken into account jointly. So if equivalence is recognized, again, the Luxembourg bar might need to look at the specific case, but that should cover the LLP structure as well.
Okay, I think it's probably time to bowl on to Spain, Michael.
Sure. So on Spain, again, important market with 71 individual members and 18 member firms located in Spain. We have been in contact with those firms registered as branches or subsidiaries of UK LLPs in Spain several times over this summer. After giving you a scare by reporting that the Spanish National Bar, the Consejo General de la Abogacía Española, has advised us on a call on 27th of May that the UK LLP would no longer be an acceptable structure in Spain after the end of the transition period. So on this basis, we made contact with all of the affected law firms, and we found that there were very conflicting interpretations of Spanish corporate law, and that there had been conflicting advice received over the past year from the Spanish National Bar as well as Madrid and Barcelona. Following that, we did a more in-depth examination of Spanish statutes. We continued our conversations with our members with offices in Spain, as well as with the Spanish Bar, who went back to the Spanish Ministry of Justice and Ministry of Industry, Trade and Tourism to what national policy would be, and we held another call with the Spanish Bar on 29 September. So we can confirm from the Spanish Bar the following, which we think is pretty good news compared to the original call with them. On Fifo, English solicitors will be able to provide advice on English and international law, excluding EU law, on a temporary basis, so long as they do not hold themselves out as abogados, Spanish lawyers. While it is mandatory for EU lawyers to advise the local bar in Spain, where they will be temporarily providing legal services, there is no mention in Spanish law regarding non-EU lawyers. The Spanish bar does recommend that the local bar be informed, though it's required. On establishment, permanent establishment, solicitors will be able to practice English law and international law under their title of Solicitor of England and Wales, so long as they do not call themselves by the title abogado. As this is just Spanish for lawyer, you may want to be careful in translations of documents, business cards, and so on. Though again, not required, the Spanish bar does recommend notifying their local Spanish bar where you will be practicing. Foreign lawyers established in Spain can partner with Spanish abogados and can employ or be employed by Spanish abogados, so long as the rules and regulations for Spanish professional societies are followed. We have confirmed with the Spanish bar now that the UK LLP structure will be acceptable in Spain. so long as they fulfill all of the applicable commercial, labor, and fiscal rules, and they register with their local bar. One of those rules is that for professional societies, at least 50% plus one of the capital and voting rights must belong to Spanish or EU qualified lawyers. This has recently been reduced from 75%. The Spanish bar has confirmed to us that, to the best of their knowledge, all of the UK LLPs in Spain will be in conformity with the law after Brexit, save perhaps one, but they know who they are. Yeah, let's try to get it back on track. So are there any questions on Spain?
Yeah, we do indeed have questions on Spain. Can EU qualified UK nationals based in a UK LLP give EU advice in Spain on a FIFO basis?
So this is okay, so this is, again, maybe the Irish PC question. Is that right?
Look forward to working.
I mean, I would give the same answer, is that it would depend on citizenship as to apply. So again, monitoring FIFO is difficult, but as Marco cautioned in a number of other jurisdictions, just be aware that EU LPP would not apply.
Okay. Looks like that's the only question we've got on Spain. So next, I think we're...
Sorry, Stephen, I think Raymond Cohen wanted to raise a point on Spain as well as communicating with me by email.
Okay, perfect.
Yes, thanks, Marco. One thing I just wanted to clarify in relation to Spain, based on the advice that we've had on the legal structure question. First of all, we've been assured that there is a grace period that's been agreed for implementing any change to your structure that you need to make, for example, to ensure that you've got more than 50% ownership within the EU. That doesn't need to be effected until end of June next year, rather than by 31st December. And the other piece of advice we've had in relation to Spain is you refer to 50% plus one in relation to EU capital and voting rights. An important technical point, we've been advised that it only applies to voting rights rather than capital and voting rights, so that it's possible to maintain your current economic structure by simply ensuring that more than half of your voting rights are held in another EU jurisdiction rather than held through a UK LLP. Does that conform with what you've heard?
Yeah, thanks, Raymond. That's great to hear. The Spanish bar has been very helpful. And again, they're looking to avoid disruptions where possible. The issue is, conformity with Spanish law. So it's great to hear that they're planning on being flexible about it, and that the Spanish government is planning on being flexible about it.
Thank you, Raymond. And I think that's a great example of the value of sharing knowledge and experience. So we're very grateful to Raymond and a number of others who've shared various things with us. So meanwhile, we have another question, which is on legal professional privilege. Leading counsel engaged by the Law Society said that privilege under EU law would likely attach to an Irish qualified UK national. Presumably, the Law Society still thinks this is a viable position. So that's clearly not a Spanish question. So I don't know, Michael and/or Marco, how you want to address that.
I can address it since I covered Ireland. It's probably one for me. Yes, indeed. We had that advice from counsel, which obviously it's legal advice we received. So we are not in a position really to argue with that counsel directly and that advice directly. But one thing we have been telling members, one note of caution on that, is that usually the privilege under EU law is attached to right of audience at the EU Court of Justice, and usually right of audience at the EU Court of Justice is only given if the lawyer has right of audience in a EU member state court. So unfortunately, with the current position of the Law Society of Ireland stating that the Irish PC does not entitle the holder to practice Irish law outside of the territory of the Irish state, this might be read as Irish PC not giving the holder right of audience in Irish courts and therefore not ensuring protection by EU LPP. But obviously, yes, the legal advice is there, and still the advice we received.
And we have another question, which I think is a general one as well. Leaving aside the QU of EU LLP, if a UK-based lawyer advises remotely to an EU-based client on EU law, and it is not clear if we are authorised to practice EU law, what are the implications of unauthorised practice of law for our clients, if any?
For clients, so the problem with this, and Michael might have contributions to this too, but the problem with this sort of not explicitly authorized provision of EU legal advice arises if someone raises the issue and if there are proceedings starting on that basis. So if the clients are fine with it, obviously the risk is lower. It's still worth for firms bearing in mind that in some cases, in some EU countries, this is happening outside of any legislation stating one way or the other whether it's allowed. But our understanding so far is that likelihood of enforcement, if a client does not raise the issue, is relatively low. Obviously, we do need to be very careful the way we phrase it, and we do need to make the point that it's not explicitly allowed. But likelihood of enforcement, we understand so far, has been relatively low for other non-EU lawyers providing similar advice. So I would say the main issue is if clients raise issues with that could be the issue.
Yeah, I think it's also worth saying, obviously, that we're not qualified to give advice on the laws of EU
absolutely.
member states, and you should seek appropriate local advice if it becomes crucial in a particular case. And obviously that frequently will be possible if you're working alongside local counsel. So we have a Belgian-Spain crossover question. A Belgian qualified A-list lawyer who is a UK national would have rights of audience in Belgium and benefit from EU LPP, which presumably would also apply to advice on EU lawyer to a client in Spain. I'm not sure I read that correctly, but anyway.
Yes, we can go very quickly on this. The answer is yes. I think that's it. Yeah.
All right. Well, with that unanimity, I think we'll attempt to move on to Greece.
All right, on Greece, we have 86 individual members and 9 firms established in Greece. English solicitors are vital to Greece's shipping industry, where maritime contracts are often written using English law. The Greek bars at Athens and the Port of Piraeus very much recognize the importance of English solicitors and are doing what they can to ease the transition, but they are constrained by Greek legislation, which makes the provision of legal advice by non-EU lawyers all but impossible. We are working with the Greek bars on potential solutions, but as these would likely involve lobbying the Greek government to change legislation, it's unlikely that we will be able to liberalize the market before the end of the transition period. So there will be a difficult transition for many of our members there. Regarding Fifo, temporary practice by foreign lawyers under home title is not permitted in Greece. Though, again, in practice, we are aware that many third country lawyers, and particularly Chinese lawyers, do Fifo regularly in Greece. In theory, though, Fifo is not permitted even on UK and international law. English solicitors can provide remote advice on UK and international law, though not on EU law. Arbitration by foreign lawyers is permitted, but not mediation. On establishment rights, as mentioned, provision of legal services by non-Greek or non-EU lawyers is not permitted. The Greek bars are sympathetic and are trying to requalify as many solicitors as possible as Greek lawyers under Article 10 of the Lawyers Establishment Directive. However, there will be many solicitors practicing in Greece who will not requalify, and this option will not be available after December. So in the future, solicitors will not be able to work in Greece. Now, one proposed solution is for solicitors to work as business consultants. Careful, it's not legal consultants, but business consultants. But the Greek bars have warned us that the solicitor would have to be very careful not to cross the line into providing legal advice, as even Greek citizens are often prosecuted for providing legal advice illegally. And some of you may remember that back in the late 1990s, a number of our members were prosecuted in Greece before the EU directives came into effect. So anybody considering this option should be sure to seek Greek legal advice and make sure that they stay within the bounds of what's allowable by Greek law. As mentioned, we're working on long-term solutions with the Greek bars, but at the moment, practicing rights in Greece are practically non-existent. Same thing, the LLP structure is not an accepted legal structure in Greece, so firms there will likely have to restructure into Greek or European entities before the end of the transition period. Again, we're looking at long-term solutions to this, but it's tough to get anything in the next 2 months. Any questions on Greece?
Yeah, there's a comment which is very helpful. We have a Greek firm with UK valve partners, and have been told we may not need to change this, although we have a UK resident, but an EU PC holder and national is in reserve. So clearly they're ready to change it if required, but they're currently getting the advice that simply having valve partners in the Greek structure doesn't need a change. Any comments on that, Michael?
Yeah, I mean, make sure you're in touch with the Greek bars. As I mentioned, they're being very helpful. They are trying to ease the transition to the best they can, and they're being flexible. If, for example, an interpretation of Article 10 requirements as much as possible. So if that's what you're getting from contact with the Greek bars, then it should be acceptable.
And this is a good example of the value of sharing. That came from the bar, albeit indirectly. So good news there. So keep us informed how that works out in practice. And particularly, I mean, Greece is like Luxembourg is a country where I'm sure we can benefit a lot from the experiences of individual member firms, each of which will probably be slightly different depending on their structure and possibly also their contacts.
Yeah, sorry, Stephen, I can't stress enough how much we benefit from input from our members. We're dealing with going from one set of regulations across all of Europe to 31 very different, very complex regulations in all the different jurisdictions. It's complicated, and it helps very much if members with experience on the ground can feed back into us what they're hearing from lawyers there or from the bars there.
Right. With that, we can move on to Switzerland. Michael.
All right. On Switzerland, we have 249 individual members and 8 firms in Switzerland. And I'm going to start by noting that many aspects of legal practice are regulated at the canton level rather than nationally. Now, Switzerland is going to be different from all the rest of the jurisdictions we've discussed because it is not governed by the UK-EU withdrawal agreement, but rather by the separate UK-Switzerland Citizens' Right Agreement, which was agreed to on 20th of December 2018. So this agreement sets out the rights for the 14,000 Swiss nationals living in the UK and the 40,000 UK nationals living in Switzerland. While the Swiss agreement broadly mirrors the citizens' right chapter of the UK-EU withdrawal agreement, on legal services there are some differences and provide considerably more rights for lawyers practicing in each other's jurisdiction. On Fifo, there's an interesting issue, which we're calling the Mode 4 cliff edge. Under the Citizens' Right Agreement, UK lawyers will be granted favorable access compared to other third country lawyers. They will be able to enter Switzerland for up to 90 days per year to serve clients without needing a visa. But in order to take advantage of this, you must have a signed and commenced service contract in place before the end of the transition period. I think the intention was for lawyers to be able to finish up existing contracts rather than to grant permanent favorable temporary practice access. So in the event that you do not have that contract in place, then all that happens is you're subject to the same temporary provision of legal services rules as other third country nationals, which in Switzerland means that you would have to apply for a L work permit and visa in order to be able to provide temporary services if you're doing so for more than 8 days per year. We have flagged that this Mode 4 cliff edge presents an issue to our members who regularly provide Fifo services into Switzerland. We flagged this to the UK government. So in the future, this may be something to seek improved market access for with Switzerland when the current Citizens' Right Agreement expires. But that's 4 years from now. On establishment rights, on the other hand, the CRA it provides very positive results for UK lawyers. As with the EU withdrawal agreement, the CRA grandfathers UK lawyers who have transferred into the Swiss profession, as long as they remain registered with their local Swiss bar, they will remain as Swiss lawyers. Likewise, or not likewise, but UK lawyers who are already established in Switzerland and registered as European lawyers under the CRA will be able to continue to practice as European lawyers so long as they remain registered. So this is very different from the withdrawal agreement where the right of UK lawyers to continue to register as European lawyers under the directives expires on the 31st of December. In Switzerland, they can continue to be registered as European lawyers with the same practicing rights. And in fact, there's beyond that, there's a 4-year grace period after the end of the transition period for UK lawyers to both register as European lawyers or transfer into the Swiss profession. So for a period of 4 years, basically the situation remains as it has been under the EU directives. So that's a much better establishment rights than are possible under the UK-EU withdrawal agreement currently. On legal structures, the CRA is silent. It talks about individuals, but not about firms. And again, the rules for foreign law firms are often regulated by individual cantons. And one of the questions often is whether the UK LLP intends to represent clients before Swiss courts or not. Generally speaking, a branch of a UK LLP does not benefit from rights of audience and representation of its clients before Swiss courts, but the exact application, again, depends on the canton. Now, I do have a note that we have some reports from UK firms that have encountered problems in Geneva and Zurich and are being told that the UK LLP structure does not meet structural and economic independence criteria required for Swiss lawyers, putting Swiss qualified lawyers working for UK LLPs at risk of being struck off the register. So we'll be investigating and monitoring this situation further. Any questions on Switzerland?
There's nothing in the chat at the moment, Michael.
Great, we're getting back on time.
We are indeed. We are indeed. But definitely, we'd love to hear from those firms in the category you mentioned if they do encounter further problems. So we're on the home straight. We now have a double act dealing with the Netherlands and Italy. I'm not sure which you're taking first.
Right. So I'll cover the Netherlands, then Marco will cover Italy, and then we'll take maybe questions for both countries together.
Sorry, there is a question just come in just before we come on to that. Can contact with client cover matters unearned as at the end of the year? That's a Swiss question.
So yeah, the CRA is not exactly detailed in matters of the contract, and we have sought clarification from the MOJ on what exactly it covers. Marco, do we have an answer on these questions yet?
No, not yet on this specific question. My impression, based on reading the text of the CRA and other interactions with relevant bodies, is that the answer is no. The contract needs to cover the services that will be provided on a temporary basis. If there is any service that is not in the contract, then that's not covered by the CRA, and you have to go through the visa and work permit. But we are confirming this with the MOJ, as we are the question that immediately follows, whether the number of days that you can spend in Switzerland per year is down to the individual lawyer or to the whole of the firm. So we are confirming these points with the relevant authorities. And we'll follow up, obviously, with members on this.
Yes, the question about counting days is reminiscent for me of the Indian rules, where for tax purposes they count the entire firm as one person. But anyway, let's see. Contract is therefore no more than a normal client care letter. So further follow up.
The answer is yes. We got this confirmed. Yes.
Yep. All right. Let's now really move on to the Netherlands. I know there's more questions coming in, but I think we'll move on to Netherlands, and we'll come back to any further Swiss questions at the end. Otherwise, people will be constantly anticipating the Netherlands and Italy.
All right. On the Netherlands, foreign lawyers in general have very broad practicing rights in the Netherlands, and so once our members become foreign lawyers, generally speaking, they'll be facing fewer disruptions in that move from European lawyer to foreign lawyer than in a lot of other jurisdictions. And there are a lot of members in the Netherlands, 104 individuals and 9 English firms. We have been in communications with the Dutch bar, and they have clarified the practicing rights for our members in the Netherlands. So on Fifo, foreign lawyers, including English lawyers after the transition, can provide temporary legal services. They can provide legal services so long as they do not appear in court, that their advice and services are restricted to formal client meetings and work in the margin of these meetings, such as emails and calls, and that they do not hold themselves out to be Dutch lawyers. So solicitors will be able to provide advice in English law, international law, and even EU law. They can also represent clients in arbitration, conciliation, and mediation. On establishment rights, similarly, foreign lawyers have broad practicing rights in the Netherlands. You can practice home country, that is English law, and public international law, but not Dutch law. Generally speaking, foreign lawyers cannot appear in court, but anybody can appear in Dutch court, including foreign lawyers, for administrative law or cases where claims are under 25,000 euros. Generally speaking, I haven't been talking much about LPP, but in this case, since practicing rights are so broad, I will mention that LPP applies only to Dutch advocaats, those on the roll of the Dutch bar, and so it does not apply to foreign lawyers, and it does not apply to in-house lawyers, for that matter, in the Netherlands. The Dutch bar has confirmed to us that UK law firms will be able to continue operating in the Netherlands without restructuring. The Dutch bar has not raised any issues in relation to UK LLP structures considering continuing to operate in the Netherlands post-transition. Dutch lawyers are allowed to partner with third country lawyers if these are members of a professional organization which is recognized by the Dutch bar, and the Law Society is such an organization. So solicitors can share profits and fees with Dutch advocates. And on to Marco for Italy.
Right, Italy. Last but definitely not least, so very quickly in Italy, and that's the reason why we decided to cover them both together. In Italy, really, the situation is pretty straightforward. Essentially, the Italian Bar Association only regulates lawyers that provide advice on litigation. What this means is that the only activity that we will say is reserved to Italian qualified lawyers, avvocati, is representation of clients in court, client documents, etc. So in order to continue providing this type of service to clients, one needs to be qualified as either an Italian lawyer or a EU lawyer. However, UK qualified solicitors will be able to continue advising clients on pretty much anything else, because foreign lawyers in Italy de facto are not regulated. So they may practice in Italy under their home country title. Obviously, they cannot use the Italian qualification title of avvocato, but they can advise on home country law and public international law. On EU law, there will be similar observations as we have made for other countries where advice on EU law is not explicitly allowed nor forbidden, but because the Italian regulators do not regulate provisional legal advice beyond litigation, I think we can be a little bit more relaxed on this type of advice, on EU law advice in Italy as well. Same applies to Fifo. It is not regulated, so as long as you don't operate in any area which is to do with litigation or contentious legal advice, we understand that that's tolerated and simply not regulated. And finally, on legal structures, that's perhaps the only aspect where the situation is slightly more complex. If your law firm does not provide any advice which has to do with litigating in Italian courts, so providing documents within litigation, then again, these matters of legal structures are also not regulated in Italy. So our understanding is that you can use any legal form. However, if you do provide advice on litigation, you cannot operate the litigation practice through a branch, for example, of a UK LLP. So firms that indeed provide advice on litigation in Italy will need to restructure at least as far as their litigation practice is concerned. Restructure to a legal form that is recognized in Italy or the EU. Very briefly on partners, the Italian qualified lawyers, this is an issue that is a query that has come up, speaking with members, but we understand that English qualified solicitors will be able to continue partnering and sharing profits and fees with Italian lawyers after the end of the transition period. So that's very briefly Italy. Let's see if there are any questions on either Italy or the Netherlands.
Well, there was one question left over on Switzerland. If you have a framework agreement with a Swiss client for a term expiring, say, in 2022, would that count? That's probably one for Michael.
Yeah, I think so.
Yeah, I would agree. Yeah.
Good. All right. Then moving on to Italy. In Italy, presumably advising on litigation means Italian or EU court proceedings?
It does, yes. Yes. So anything to do with court proceedings in Italy is reserved for Italian avvocati, yes.
But not arbitration, for example?
Not arbitration. No, arbitration is regulated differently in Italy, and we understand that third country lawyers can represent clients in arbitration in Italy.
All right. We haven't yet received any other questions relating to either Italy or the Netherlands. I'll just give it another minute to see if any pop up. Well, I think what we'll do is I will now invite some remarks before we finish from Mikel Lawrence. We'll see what other questions come in, and after Mikel's made a few comments, we'll go back and mop up the remaining questions. So, Mikel, do you want to share a few thoughts with us, giving us time still to go back to the other questions afterwards?
Sure. Thank you, Stephen, and thank you to all of you who've given a couple of hours of your time this morning for this overview of the regulatory framework of for the provision of international legal services post-transition period. I realise there's a lot to take in, and indeed one of the main impact on Brexit for legal services is the move to 27 or 31, if we include EFTA, but different national regulatory regime. To sum up, maybe 2 or 3 takeaways as far as I'm concerned. First of all, a deal. I mean, if there is one, we're still waiting on the outcome of the negotiation between the EU and the UK, but a deal will be thin as far as market access for legal services are concerned. Will be a third country moving forward in any case, and the national rules on third country lawyers and third country entities will apply. And I think we have seen that looking at 10, 12 jurisdictions this morning. A deal will not be completely insignificant, though, and that's the Law Society position on the issue. It could help us negotiate other agreements moving forward, and we've been lobbying on, for example, the Lugano Convention on the recognition and circulation of judgment. It could also make a difference in some jurisdictions, so provide access to establishment of solicitors in France. We mentioned that, but it could also speed up decision making in a few jurisdictions where decisions are still pending. We mentioned France, Luxembourg, potentially Germany as well. And indeed, one of the challenges of our discussions and engagement with European bars and law societies over the past few years has been often them waiting on the outcome of negotiation at EU level. Obviously, time is running out. We are 7 weeks away from the end of the transition period. Another thought on Fifo. Obviously, we are in a pandemic scenario at the moment. Not much Fifo going on, but post-pandemic, seek to return to some form of Fifo as you were doing pre-pandemic. Obviously, will be subject to immigration and mobility provisions moving forward. There may be a need for business visas. We'll have to see what the situation is, whether there's a deal or not. We know that some of you will be taking additional risk management measures in relation to Fifo. You may be registering solicitors as established in some jurisdiction if they are doing Fifo on a regular basis, or you will bring in some local lawyers for meeting with clients and so on. What we will do as the law society is we will monitor that issue very closely, and we will be using that circulation list that we've put together, what we call the Irish PC list, to alert you immediately if we hear of any concern or if any actions being taken on Fifo in any jurisdictions. And finally, again, I said there's a lot to take in, so we remain available. Marco and Michael are 2 policy advisors for Europe, as well as myself and the rest of the team, to support you and to speak to you about your respective Brexit contingency plans. And yes, we obviously will remain available for any further follow-up or questions you may have after this session this morning. So I'll stop there. Stephen, I don't know any more questions that's come in the meantime?
Yes, I have. So just dealing with them, there's another Swiss question. What is the difference between a framework agreement and a contract which covers matters unknown at the end of the year?
So maybe I'll just read what the UK Switzerland agreement has to say on this. So this is Article 23, rights of persons providing services. persons providing services from Switzerland and the United Kingdom shall have the right to continue providing services in the territory of the other party on or after the specified date for a period not exceeding 90 days of actual work in a calendar year, subject to the following conditions. 1. Persons providing services must do so on the basis of a written service contract, which was concluded and the performance of which started prior to the specified date. And there's the footnote there says, for greater certainty, written shall include in electronic form. And 2, the provision of services may not continue beyond the period ending 5 years after the specified date, unless the period is extended in accordance with paragraph 2. So that's all that the withdrawal agreement has to say on the issue of temporary provision of services and the need for a contract. Hence our need to clarify with the MOJ, potentially with their Swiss counterparts, what exactly this means. So this is the reason why we can't answer your questions with more specificity until we hear back from the MOJ.
Okay, and then finally a few general questions. Is there any hope that an FTA with the EU will clarify the ability to advise remotely or by FIFO, at least on home and international law?
Yeah, I think Mikhail touched on that, and unfortunately it is very unlikely to be the case, at least in the short term. But as Mikhail said, we do hope that will very much welcome any FTA, because it would offer the basis for further conversations with the EU to have a better deal in future and improve on that deal. But in the short term, FIFO is very unlikely to be addressed. I don't know if, Mikhail, you have anything to add to that. But yeah, otherwise, yeah, no, I think that's.
Hi, sorry. I mean, obviously, what would be interesting in a deal is any mobility provisions which are included in the deal. You know, things like business visa, short-term business visitors, independent professionals. You know, all these categories which are on a deal. You know, it may have an impact. Again, we would expect most of you to seek to continue FIFO. We talked about the regulatory.
So I think we might have lost Mikhail there.
Yeah.
Anyway, I think we got the general gist. We've just got a couple of minutes to go. Let's just take this question. Is there a list of EU 27 jurisdictions where even remote advice on EU law is not permitted?
Yeah, so this is part of the country-by-country guidance that I think we distributed to participants to this call. I appreciate it. It's quite a long guidance, so it might take some time to digest it. But each of the profiles of the countries there has a section on EU law advice, both remotely and FIFO. So yes, that's information contained in those country-by-country papers.
Okay. And generally speaking, where an EU member state prohibits the provision of UK international law advice, either via FIFO and or remotely, post the 1st of January, will this be solved by the solicitor being dual qualified as opposed to UK qualified, and vice versa? Generally speaking, where an EU member state prohibits the provision of EU advice, either via FIFO and or remotely, post 1st January, will this be solved by the solicitor being dual qualified as opposed to UK qualified?
Yes, where any member state, sorry, I just need to run through the question. Yes, the answer to the first question is yes. Where a new member state? Yes, because the EU, so the answer is yes to both questions, because the EU qualification, I mean, any EU member state qualification enables the holder to advise on EU law, and provision of advice on UK and international law. Yes, because the EU qualification will enable the holder to continue registering as a EU lawyer in that member state, provided that they also meet either the residency condition at the end of 2020 or the citizenship condition. So the answer in those cases is yes to both questions.
There's a follow-up question on Switzerland. I suspect, though, probably Michael can't add anything to what he already said on that. Michael, I don't know if you've had a chance to read that.
Yeah, I mean, basically we're seeking clarification from the MOJ. So, you know, hopefully once we have clearer guidance from them on what the intention was behind that little bit on contracts and temporary service provision, we can get back to our members with more detailed guidance.
Okay, and we do now need to stop, I think, but there is a question about circulating our research within firms. Please do it on a confidential basis. We don't want this getting out into the public domain because it might harm our position with bars and push them into approach. So we do want to keep this confidential, but within your firms, absolutely, and we will keep it up to date. All right, I think it is now 12 o'clock. We promised to finish promptly. If you weren't all on mute, I'm sure you would join me in thanking Marco, Michael and Mikkel, and we look forward to remaining in touch with you. Thank you very much indeed.